of concern to me that I want to mention. First, this case involves a termination of parental rights, and as I'm hopeful you are aware, that you are entitled to expedited handling under the rules of procedure. This court inadvertently did not put you on that track and just handled this as it would handle a typical case. How is it that you didn't notice that and bring that to our attention? Because this could have been handled much more expeditiously.
Yes, Your Honor, we could have proceeded under 9146. Of course, this is a non-final order.
Regardless, it involves a termination. And we're required by the Florida Supreme Court under the rules to handle those a certain way.
Yes,
And I think as, an officer of the court, if we somehow let it slip through the cracks, that you have an obligation to bring that to our attention.
I understand and appreciate the court's desire to expedite these cases quickly. So I certainly understand that concern.
Well, going forward, you don't assume we're infallible. We're pretty good. This is the first time I've seen this happen, but it's something you should be paying attention to. And the second thing I want you to start with, as you mentioned, this is non-final. It is a cert petition, yet there isn't any argument addressed to the cert standard in the brief, in petitioner's brief.
Yes, Your Honor.
It's entirely talking about abuse of discretion. You haven't informed us at all of how we even have jurisdiction.
Well, I agree, Your Honor. Essentially, I'm happy to do that here today.
Well, it's supposed to be in your petition.
Yes, Your Honor. I understand that. I believe the facts as they're stated in the record evidence show that there's been a departure from the essential.
Irreparable harm is what we need for jurisdiction.
Yes, Your Honor. And certainly we're gonna make that argument here today that there is irreparable.
Well, you're going to argue something that wasn't argued in your petition? We can't let you do that. That's, that's not how it works.
Yes, Judge. And I think just by looking at the record evidence itself, we can certainly get there. I mean, I certainly think when we look at the facts and the decision of the trial court, certainly there's irreparable harm there.
How?
Well,
He intervenes, the court makes a decision, and the case keeps going forward.
well, Judge, our position is he should never be allowed to intervene in the first place. Once you allow him to intervene and give him party status, it starts a domino effect in this case. And I'm happy to discuss that further, but there is certainly irreparable harm, let's say, to the child or to this adoptive family who's attempting, the child's now 1.5 years old.
Well, this man was in the delivery room when the child was born.
Yes, Your Honor.
Seems to me that if there was a concern about delay, maybe he could have gotten notice.
Well, and that goes to our argument. I think it's important to realize that under the statute, under Chapter 63, the important issue here, really the material issue at the heart of the case, is whether or not the birth mother identified the putative father to the agency. That's really, in these cases, as you can imagine, sometimes these birth mothers have friends, they have boyfriends, they're not the biological father, they have family members.
I understand they have a right not to do that, but it appears to me, and it was the trial court's conclusion, that there was some dispute about that.
An argument is, of course, that's where the trial court erred, that there was no material dispute.
The agency was aware that he was there at the hospital. He was there in the delivery room. They spoke to, I think the mom spoke to somebody from the agency on the telephone. There was a discussion about that.
And absolutely, you're correct, Judge, that they knew he was there, they knew he was in the hospital room, but that doesn't mean that they knew that he was the biological father.
Do they have to ask? I know all this stuff, and I stand mute.
Well, I think the important thing is, Judge, what the birth mother does. Does the birth mother identify the biological father, the putative father, to the agency? That's what's really important.
So willful blindness on the part of the agency is okay.
Well, I think it's.
So then we end up in a situation like where we are now.
I would say, Judge, I wouldn't say it's willful blindness. I think it's respecting the birth mother's right to her privacy And so the Children's Home Society case talks about that. Despite what the agency may think is the best route, I would venture to say the agency wishes that all birth mothers would identify the birth father immediately so that they can go through, serve him with the notice of intended adoption plan and litigate this accordingly, like 99.9% of cases are handled.
Well, I
That-
mean, I think there was testimony that she did by first name, they had discussions, and I think her testimony, or the inference from her testimony is that she was dissuaded from doing so.
Well, I think, Judge, multiple times, consistently throughout the case, the birth mother fails to identify the biological father. Now, if she says his name is, the testimony in the record says that she identified him or talked about him as Freddie or Darius. That's obviously impossible to go, that's not a known and locatable father as contemplated by the statute in chapter
And
63.
the agency has no obligation to ask, like, we need to give him notice, tell us how to reach out to him. And she's like, no, I don't want him to know. So they're like, okay.
Essentially, yes, and I think that's what the Children's Home Society case says, is that once the birth mother exercises this right to privacy, that the agency, it's not the agency's duty to serve as, private investigator and track these guys down. Certainly, if she comes forward and says, this is the biological father, this is his name, this is his full name, here's how you can get in contact with him, he certainly then becomes a known and locatable father. And that would trigger them having to serve him with a notice of intended adoption plan. But in this case, calling him Darius sometimes, Freddie sometimes, that doesn't then become a known and locatable father. And it's not incumbent on the adoption entity at that point to then search for this birth father. If she's coming to the agency and saying,
There's a difference between asking a follow-up question and doing a search from just nothing.
I understand. At that point, though, Judge, the birth mother is clearly not identifying the birth father. And she makes several substantive steps. It's not merely as, hey, who's the birth father?
The affidavit. I'm familiar with the record.
So I think,
But
Judge,
it's, frankly, I'm scratching my head. If you want to avoid ending up in a situation like this, why there isn't some, maybe you're not required to do anything. That's just the way the law is. But I don't understand, as a matter of prudence, to avoid this, why you wouldn't take those additional steps.
I hear what you're saying, practically.
He's at the hospital, just serve him with a notice.
I certainly understand, truly, and I'm not giving that lip service. I understand the logic there and the principle. I think the agency is trying to toe the line between what they view is the law in this area, which is if the birth mother comes forward and does not identify the birth father, that they have to respect her right to privacy.
Ultimately, I think everybody wants the best interest of the child, which is permanency, as soon as possible, and we've got the opposite here.
I agree, Your Honor. The child's a year and a half, has been with the adoptive parents the whole time. And I think the statutes, chapter 63 specifically contemplates a situation like this. What happens when the birth mother, fraudulently or not fraudulently, fails to identify the biological father in this case? And the statute, the legislature, clearly talks about this. It provides that any person, I'm quoting from 63063 subsection 2, any person injured by a fraudulent representation or action in connection with an adoption may pursue civil or criminal penalties as provided by law. A fraudulent representation is not a defense to compliance with the requirements of this chapter and is not a basis for dismissing a petition for TPR, a petition for adoption, for vacating an adoption decree, or for granting custody to the offended party. The legislature finds there's no way to remove all risk of fraud or misrepresentation in adoption proceedings. It's provided a method for absolute protection of an unmarried biological father's rights through compliance with this chapter. In balancing the rights and interests of the state and all parties affected by fraud, including the child, the adoptive parents, the unmarried biological father, the legislature has determined that the unmarried biological father is in the best position to prevent the effects of fraud and therefore has the burden of preventing fraud. So the legislature did contemplate a situation like this where the birth mother was saying, I'm just not going to identify who the biological father is. And the legislature is saying they can pursue criminal penalties, they can pursue civil penalties But the fact of the matter is that that's not a basis for denying a petition to,
Okay, well, I want to come back to the issue here, which is intervention, not whether or not it's a proper termination of parental rights that should, against the father, or whether it has standing or any of that, but just whether he can intervene. And you've addressed it as an abuse of discretion issue, which it is not. So, and I think you've alluded to, you've got to show a departure from the essential requirements of law. In reviewing your termination petition, one of the things I think in the conclusion is you ask the court to, among other things, terminate any inchoate parental rights. So why doesn't someone who has inchoate parental rights, I mean, it's yet to be determined, but they're at least inchoate, why isn't that a proper person to intervene?
well, I think in this case, Judge, if a birth father has not been identified by the birth mother, the statute clearly says they're not even entitled to notice of further judicial proceedings. And so if you're not even entitled to notice of the further proceedings, then certainly you wouldn't have standing.
It strikes me, you're way down the road on this. You go back to what Judge Kelly said earlier, you've got to show departure from essential requirements of law, irreparable injury, and you don't even address that in your brief. You're basically telling us, go look for it. That's not how it works. So if that's how we view it, where do we go with this?
Well, Judge, I think if we look, for instance, specifically to,
We're not here to be an advocate for either party.
I understand.
So we're faced with a petition that doesn't even make the right arguments.
Yes, Judge. I think if we look specifically, you had raised earlier, if we look specifically at this intervention statute, whether or not he has I'm sorry, not the statute, the intervention issue, and we look about whether or not he has standing, the Children's Home case clearly states that he does not have standing. In fact, it says specifically in that case, no putative father had standing here. A biological father who is not identified by the mother, like in this case, by the time she consents to adoption, but who wishes to preserve the right to notice and consent, must register with the Florida Putative Father Registry by the date a petition for termination of parental rights is filed. No putative father did here. No putative father had standing here. And that
Why
was,
are you asking us to terminate inchoate rights?
well, in the petition, Judge, that is standard for anybody who's not named in that petition. So in the petition, we always ask the court to terminate parental rights of any birth fathers who are not named. And essentially what that does coming back.
And I think there was also a question somewhere I saw in the record. I'm sorry, I interrupted your answer. Go finish. I'll hold my question.
So essentially, that takes care of any birth fathers who have not been named or who have not been identified. And so that way the TPR, essentially, the termination.
Okay. So, but not named, not identified, but aren't you supposed to search the registry before you file that petition?
So essentially, Judge, you have to search the registry before a TPR petition is.
Right, so when you file it, you're asking me to terminate 08 rights for
Before
people that
TPR,
aren't out there, that aren't named, but under your argument, you have no obligation to even give them notice.
well, I think you would certainly search and file that registry certificate saying that the PFR registry has been searched before any TPR would be entered. So that way the
It
court
seems to
knows.
me that there was some dispute pointed to in the record as to when you actually did that search. I'm not recalling the details of it off the top of my head, but I think there was some dispute about that too.
Well, we know, Judge, that the birth father registered with the putative father registry on
All this happened,
August.
boom, boom, boom.
It did, certainly. The birth father registered with the putative father registry on August 25th. The petition for TPR was filed on August 20th. So about 5 days before the
Yeah, but
registry.
then you filed the certificate of searching later. And I actually thought I saw something in the record that like a clerk stamp or something that gave me pause about this date of the 25th not being correct.
I'm happy to look at that in the time where we're giving rebuttal and report back, but
Speaking of which, you are at 15 minutes. I know we've eaten up a lot of your,
no problem, Judge. I'll reserve the rest of my time. Thank you.
all right, thank you. All right, sir. Have 20 minutes for your argument. You don't have to use all of it, but you do have 20 minutes and I'm keeping track of your time.
Hello, address the courts. My name is Freddie Edwards. I would like to reserve 5 minutes for rebuttal as well.
No, you don't get rebuttal, sir. I'm sorry, it doesn't work that way.
Oh.
He gets to come back and rebut you because he's got the burden here. You
Yes,
get to
ma'am.
make your
Yes.
argument and you're finished.
All right, so as the record shows, the identity of the father is very important when it comes to being involved in a situation. Whenever the mom does, I like almost dissected chapter 63 by being in this situation. Whenever this is how it goes, and you're definitely correct, and this is all statutes by legislation. Even if there isn't a father that's unknown or known, at the time of filing a petition for parental rights, and remind the courts that they could take judicial notice that this occurred from a chapter 39, which jurisdiction was still supposed to be, they were still supposed to have jurisdiction. This agency was supposed to intervene in the chapter 39. Instead, they filed their own petition to terminate parental rights proceeding to adoption, which is not correct when there's a chapter 39 involved. You're supposed to
I
have,
thought maybe the chapter 39 was filed after the term.
no, the chapter 39 was
It
initial.
was pending at the time of the termination.
At the time the mother terminated her rights because there was an
Didn't
open
chapter
30,
39 get dismissed?
because the mother signed her rights to the, which,
Right,
that's
at
not
the
how
behest
that's,
of the agency, they weren't,
And as-
somehow they were involved in.
so in the law, it states that whenever there's a chapter 39, and the reason that this agency needed to be interveners, because they're supposed to intervene in the chapter 39. They're not supposed to just, and the chapter 39 was closed. It was filed first. It was open first, and it's the reason why the mother came to the agency for help, because she was facing the chapter 39. It was open. But once the 39 was closed, because they didn't intervene, they just took the mother's signature and saying that, hey, this is her decision. We don't need you guys anymore. We'll take over from here. Well, according to the state of Florida, that's not how that goes. If there's a chapter 39 has jurisdiction until the adoption is finalized. Speaking about the timing and the filing of parental rights, at the time of filing parental rights proceedings, you're supposed to already have a certificate stating that you did a diligent search. My daughter was born August 19th. I found out the day that she was born from CPS that there was an adoption process going on. The mother, this is when her moment, she had to tell me, and this was like right after my daughter was born, and she was told to plant seeds to me,
Right.
to tell me about it. I'm trying to figure out how can a mother that's 9 months pregnant, just now coming to this agency, 2 weeks before delivery, can plant seeds and under duress. At the same time, she's not a counselor, she's not a professional in this field, so I don't understand why she's held accountable. She does plays a part, but this agency has a responsibility. I don't know if my name was George, James, Gary, however you name me, even under chapter 63.089, there's a word called prerequisites. Prerequisites mean that you're supposed to have everything together before you even be allowed to move forward. In order to have a hearing, they didn't meet the prerequisites to even file in the 63, because they didn't reach out to the Putative Father Registry, and they didn't reach out to Vital Statistics, and then they didn't even also do the simplest thing. You could put a publication in a newspaper if there is an unknown, or if he's unknown and location is unknown, that certificate as well meets parts of the prerequisites to even get a chapter 63 hearing. Sorry.
No, it's okay.
I don't know too much about the law, but it's simple, and the way that proceeding moved forward was like so out of the
I
letters.
think you've made your position, I want to commend you. You made your position very clear in what you filed in the court. So you don't owe us an apology.
Thank you. And so my only concern, I just would like for this petition that they're filing to be dismissed, in my response because initially this case hasn't even, I don't even know how we even had it. I hate to,
Well, you know, and I do want to just tell you that what we're here about today isn't the ultimate outcome
yes,
of how this case should go and all these issues that you're very concerned with,
yes,
understandably. This is simply about whether the trial court, we call it departed from the essential requirements of law, and that means not just made an error, but made a very, very serious error in allowing you to intervene that will cause harm that cannot be remedied later in an appeal from a final order. So we're just here about that one decision, about the trial court allowing you to appear in this case.
yes,
So, and the other stuff is important, but it's not the main focus that we're here about.
yes. So, I don't think I need the whole 15 minutes for,
Well, you do not have to use it, sir.
Thank you.
It's up to you.
thank you.
All right, thank you. All righty, you got 5 minutes, sir?
Thank you, Judge. And Judge, I know that you said that you're familiar with the record. I do just want to reiterate that on 3 separate occasions, the birth mother here, under oath, did tell the court that she did not identify the birth father to the adoption entity in this case.
I know, and your position, argued in your petition, is that it's undisputed because of those 3 events.
That's correct, Your Honor. And so, with that, Judge, in taking those facts, and those sworn statements, and comparing that to the facts in the Children's Home Society cases, which is obviously in our brief, it's our position that the court did depart from the essential requirements of the law. Just like in that Children's
Well,
Home
it's the
Society
position
case.
today, but it wasn't the position in your petition.
Yes, Your
Because
Honor.
all you talked about is an abuse of discretion. You put us in a very difficult position.
I understand that, Your Honor. But if we look at that VD case, at that Children's Home Society case, it's clear from that case and the language in that case where the court found that the birth father in that case, under very similar circumstances, did not have standing. And that's essentially what we have here. We have a birth mother. It is undisputed. She never gave a full name. She referred to him as 2 different names. She said over and over that she should have identified him, but that she didn't. And so he was not a known and locatable birth father at the time that she executed her consent to adoption. And that's really the crux of this case, Judge. Did she identify him at the time she signed her consent? She clearly did not. There really is no, and contrary to what the court wrote in its order, there is no genuine issue of fact there. She simply didn't identify the birth father at the time she executed her consent for adoption. And therefore, based on both the statutory law and the language in the Children's Home Society, which says that he clearly does not have a standing in those types of cases, we'd ask the court to reverse the decision of the trial court.
Quash, and assert we quash.
Thank you, Judge.
Thank you. All right. Next up this morning, we've got KMG